let's perhaps kick off. Tom, are we good to go?
Yep. Yeah, all good.
Okay. All right. Thanks everyone for coming along. We appreciate your time today. We're going to do a bit of a speed run through of some of the changes that came about in 2023. There's a fair bit on, so we're skimming over some of the things that have probably the most application to you on the line. And there are obviously some other changes. If there's anything that you want further information on, or if there's anything that we haven't touched on today but you're aware of, please reach out to us. And of course, we're happy to run through these with you in more detail. I don't want to scare anyone today, but there has been a fair bit of change that's come about as part of the some 2023 amendments to the Fair Work Act. These changes have come about because obviously with the changeover in government, there were a number of commitments made to protecting worker entitlements and strengthening the workplace relations framework across Australia. So in terms of our agenda today, we'll talk through a number of those amendments. Jackie, do you want to jump to the next slide? We're looking at the amendments that were brought about with the Secure Jobs and Better Pay amendment, the Protecting Worker Entitlements amendment, the changes to Respect at Work, and then some modern award changes as well. We'll run through these in more detail with you, but I will hand over to Michael now to run through the Secure Jobs Better Pay amendment. Thanks, Michael.
Thanks, Dan. Thanks for the introduction. Look, guys, there has been a lot of changes this year, as Dan said, as a result of the Albanese government going through and strengthening the industrial relations framework to address cost of living pressures and also to promote gender equity, which is a key platform that the Labor Party has run on and promoted in recent years. So the amendments are kind of twofold. There's the first tranche, which relates to enterprise bargaining and improving conditions. We haven't really addressed the enterprise bargaining changes. However, we note that there's increased exposure to multi-enterprise agreements where organisations can now potentially be joined to other organisations' EAs and also be compelled to bargain alongside people with a common interest, which is broadly defined to include businesses and operations of a similar nature and size. There are a few other factors like geographic location, but there is some potential exposure there for particularly larger businesses. So if you are without an enterprise agreement or, you're contemplating how this might affect you, we really encourage you to reach out and be on the front foot because it's a highly contested space and there will be significant movement in 2024 onwards around this multi-enterprise platform. But today, most of our focus will be on the individual changes and how this affects businesses of all sizes. And in a nutshell, what you need to know and how you need to deal with these changes. So the changes we're going to talk about today relate to flexible working arrangements, fixed-term contracts, pay secrecy, as well as additional protected attributes that have been added to the Fair Work Act to protect against discrimination on a gendered basis. So I'll talk to you a little bit about further. In terms of flexible working arrangements, as we're all aware, employees who have served a specific length of time have always had access to request flexible working arrangements. Now, in the interest of promoting flexibility in the workforce, the Labor government has made some amendments in this area. So flexible working arrangements, in addition to the right to request, there's now an obligation for employers to meaningfully engage and consult with employees, particularly when they're going to say no. So there's now a real positive collaborative approach. So you have to get in and talk about the reasons why the requests are there and try and find ways to make it work. If it's not going to work for you, you really have to be mindful of engaging in the process with the employee, trying to find alternatives to make sure that you've done that due diligence. And if you reject it, really setting out those reasons and making sure they're legitimate business reasons. In terms of rejections, there's additional scrutiny that's going to be applied to rejections of flexible working requests, and employees now have the ability to raise a dispute through the Fair Work Commission in the event that a request is rejected. So what that means for business owners, they really have to engage in the process and really make sure they're setting out their rejections in a clear, logical way. This has to be backed by reason and evidence. It doesn't mean you have to go and make it like a legal proceeding where you go and collect evidence and compile it so robustly and particularize it, but the reason should be grounded in evidence. If something's going to cost too much, how much does it cost? Why is it not practicable to change working arrangements? Really get in and explain that. And if you do it right throughout the consultation process, you're likely to minimize those disputes. But this is an area for everyone to watch out on, as it is going to add some potential triggers, and it's likely this is going to be an area that's pushed. It's not a high threshold to get access to flexible work requests. It's a mere 12 months of service, and thereafter, these changes are there. The scope around why you can get them always exists, but now there's a real push and a real emphasis and a real way to fight back for employees if they don't believe the request was considered properly, or that it just hasn't been dealt with in the appropriate manner. So there's a process element and a substance element. Really encourage you to get across both of those aspects. The next aspect of the changes that's probably most significant relates to fixed term contracts. Now, as part of the platform of industrial relations change, there's a real emphasis on providing security to employees. Now, one of the areas that's most controversial has traditionally been around fixed term contracts and rolling fixed term contracts. In a nutshell, fixed term contracts are seen by the labour movement as a way to defeat efforts to maintain ongoing employment. They provide uncertainty to employees, even if the arrangements are quite legitimate. So, as a means to combat this, there's been some restrictions imposed around fixed term contracts, and moving forward, fixed term contracts from this week, actually, the 6th, cannot be longer than 2 years. They cannot generally be renewed or extended more than once, even if it's less than that period. And you're required to give a fixed term information statement to your employees, which is essentially like a fair work information statement or a casual information statement, which outlines the nature of fixed term employment, advertises that, lets them know what it's about, and lets them know of their rights in relation to renewals. So they're now empowered and informed to go and get ongoing employment. There are some exemptions to these fixed term contract rules, particularly for high income earners. There's also some around people with a particular skill set, really nuanced roles. And there's also some around protecting for temporary absences and emergencies. So if there is a true legitimate reason why there needs to be an extension or something like that, you know, someone's extended their parental leave unexpectedly, or there's an unexpected illness, there might be provision to extend, but there's really strict criteria about this. If you're thinking about using fixed term contracts, we really recommend you seek advice, particularly if it's going to go beyond 2 years, and particularly if you're up to that point of renewal. For contracts entered into prior to the commencement of this Act, you still have a full 2 years on your next renewal, but the number of renewals you've had beforehand actually counts. So if you renewed a fixed term contract more than twice before, these legislation may prevent you undertaking further renewals after that date. However, if you do have renewals, you will be able to extend for the full 2 years. In terms of fixed term contracts and why we see people using them, at ERS, we often get confronted with clients going, look, we really want a fixed term contract as it provides greater security around performance. We want to know that when someone starts, they are good. They are a good fit for our business and they work. A fixed term contract shouldn't really be used for that purpose. And in the employment legislation, there is almost carte blanche to terminate an employee within the minimum employment period for small businesses with fewer than 15 employees. That period's 12 months. For larger businesses with more than 15 or more employees, that period reduces to 6. And during this time, a business can essentially terminate for any reason they see fit, other than a protected reason, which of course is covered by adverse action protections which we'll touch upon a little bit later. So in terms of the use of fixed-term contracts, please make sure you're using them for the right purposes. If you are thinking of engaging someone for a longer period or a project-specific basis, consider what skill set they are, consider how much you're paying them, and really, really seek advice and be proactive on this front. You don't want to get caught out around these provisions. It's better to be certain, take the advice up front. Other changes that have come into effect over the last 12 months relate to pay secrecy and pay secrecy clauses. Now, as part of the campaign to promote wage growth and gender equity, there has been a common notion that the inability to speak about pay and conditions prevents an uplift in workers' rights. So historically, employers have used pay secrecy clauses, contractual clauses stating an employee is not permitted to discuss their pay conditions entitlements to any other person as a means to so it's a means to protect the dissemination of gossip and discussion around this. Employers have historically paid people as they see fit. There's a number of different reasons why employers do that: skills, responsibilities, and it's traditionally been seen to the detriment of employers to have that canvassed as it creates disharmony. The counter to that is by not allowing people to discuss their wages, practices that are associated with discrimination, particularly around gender and the gender pay gap and not paying men and women equally, have really come to the fore. We're not allowed to talk about pay, therefore discrimination occurs and there's no way to remedy that. So to protect against this, there's been some changes around pay secrecy laws. So from the 7th of December last year, pay secrecy laws for people who entered into contracts from that date onwards until June the terms were void in a sense, and then from June onwards, the actual terms became prohibited to include in new employment contracts. Now, for contracts made prior to that time, the pay secrecy clause is permitted until such time as the contract is varied or changed in any way. So if you are looking at promotions and promoting employees with these things prior to December last year, who might have these clauses in, be mindful that they should be addressed and removed. Otherwise, you're potentially breaching. Similarly, for all new contracts, these clauses should be removed. Now, what does that pay secrecy aspect actually mean? An employee has the right to discuss their pay or not discuss that pay. So you can't compel an employee to discuss it. Other employees can't do that either, but there is a right if they want to go and talk about that. This is an important aspect from a cultural perspective as well. It's also important to consider how pay secrecy clauses are now being seen, and it might be prudent to consider removing them anyway, particularly with more young and dynamic workforces who see these clauses in that more discriminatory light. So always consider the balance of potentially removing it anyway. And if you do need advice regarding when the timeframes around what is to take place, when is it prohibited, what applies from when, please feel free to reach out to us and we're happy to go into that in more depth. The other changes relating to, or the other primary changes relating to the promotion of gender equity relate to new protected attributes, which have been included in the Fair Work Act. So in the Fair Work Act, you're prohibited from discriminating against people on a number of specific bases that are outlined therein. Now, if you discriminate against this or take action against someone for one of these reasons, there's general protections and adverse actions risk, which are essentially claims that can arise at any time in the employment and, uncapped damages. And there's a reverse onus of proof showing that you didn't take an action to someone's detriment because of their protected attribute or right. Now, these are really tricky kind of things to deal with. If you do have someone who's raising issues or suggesting that an action has been taken against them because, or they've been discriminated against for breastfeeding, gender identity or intersex status, please reach out. Other things to consider are race, age, and the like. There's a number of things. Be across these attributes are really important to know, and then to make sure that you're not incorporating them into your decision-making process. Now, in terms of the new protected attributes, you'll note that one is breastfeeding, gender identity, and intersex status. All of these are essentially gendered in nature, and intended to promote greater awareness and protection around these things. So if you do have an employee who's seeking to change something or seeking or making inquiries around breastfeeding, be mindful about this. There has been a spate of discrimination claims that have come about since these changes have been introduced, and that's only more likely to do that. So if you are getting requests around these things or suggestions, reach out and understand your obligations. It's really important to be on the front foot in this regard.
Awesome.
Okay.
Yeah, thank you, Michael. I'll take it from here and we'll start talking about the Protecting Worker Entitlements Amendment. So the three big changes that happened here was first in July was the changes to parental leave. And then there's also coming towards the end of this year, some changes around deductions and ongoing deductions. And then a big change around superannuation in the new year. So we'll start off with parental leave, given that was the first one. So what happened there was they've talking to a bit more of what Michael said, a lot of gender focus and promotion of gender equity. You'll notice now that Fair Work has removed a lot of the gendered language. So things like primary, secondary carer, things like dad and partner pay has now been removed. Any kind of gendered language that insinuates one parent maybe has a more significant role in the pregnancy than another has been removed. They've also gone about and increased the number of unpaid flexible parental leave from 30 days to 100, and they've extended the paid government scheme from 18 weeks to 20 weeks, and they've also removed the 2 weeks of dad and partner pay, which I was alluding to earlier. Again, this is to promote gender equity. Now what parents can do with that 20 weeks paid scheme is they can go to Services Australia, or formerly Centrelink, and they can choose how much they want to take of that 20 weeks. So the couple has a bucket of leave and they can choose how they want to disseminate that. Maybe a partner takes 10 and the other partner takes 10 themselves, or whatever they would like to do. So the big takeaway here is if you do have your own parental leave policy that gives maybe more favorable entitlements, or even if it just refers to the government scheme, have a look through it and take out that gendered language, make it employee, something really neutral. And if you're struggling with that and you can't find any words because it can be a bit difficult, then of course give us a call. We can have a look over and make some of those edits for you. The other significant change is in relation to parental leave is that Centrelink, or now Services Australia, has really taken the front foot in assisting employees and employers with parental leave claims. So when an employee makes a parental leave claim, your responsibility is to simply have a chat with them, sit down with them, find out when are they going to leave, when are they going to return, how long are you taking parental leave for, and then direct that employee to go to Services Australia, submit a claim. Services Australia will then work out if that employee is eligible, and they'll contact you, the employer, and say, this is how much they're taking. These are the days that they want to have paid parental leave. This is how much you have to pay them. And then as the employer, you have to just show proof of payment of the government scheme. So the positive thing here is there's plenty of resources. Head over to Services Australia, check it out, get an understanding of it. And also work with them and the employee and start that conversation early if someone does request parental leave. And then we've got payroll deductions. So a bit of a background on payroll deductions. Plenty of you may know this already, but in the Fair Work Act, a deduction is when it's authorized in writing by the employee and when it is principally for their benefit. So that could be something like a gym membership. So I've authorized in writing, yep, I'm all good for ERS, take $25 out a fortnight for my gym membership. Previously, you would have to get a written authorization each time. This change allows employees and employers to have multiple variations over the course of their employment, and it also allows that amount to vary. So my gym membership, they put it up to $30. I don't have to write a brand new variation saying that I agree to have it increased $30. The employer can just make that change and keep taking it out of my pay throughout the rest of their employment. So a pretty positive change there and less administrative hassle for you guys. And now superannuation. So similar to deductions, I'll give this sort of overview of what super is at the moment, and then we'll talk to what those changes are in the new year. So at the moment, as you may know, it's 11%, and there's no real changes around 11%. At the moment, it's super can be paid once a quarter. However, you don't have to do it. You can do it week to week, month to month, fortnight to fortnight. Quarterly is just the minimum period that you need to pay super by. Presently, the ATO is the only body that has powers to bring action against your business for superannuation breaches. However, what they're going to do in the new year is they're going to add superannuation to the National Employment Standards, or the NES. This means that the Fair Work now has the ability to commence proceedings to recover superannuations on behalf of the employee. And unions also have the ability to support employees in that process. So breaches that you can get in trouble for are, like I said, frequency of pay, not paying it by that minimum period, which is quarterly, underpayments in a period as well. So those are your two big breaches you get called out for. So the big takeaway here is it's not just the ATO that has powers to take action against you or give you a bit of hassle about superannuation. It's also the Fair Work Ombudsman can commence proceedings. The union can support your employee and give them assistance. So it's really important you stay on top of those superannuation payments. Make sure you have evidence of them. Make sure you're paying the correct amount and sense checking, and then also make sure the frequency of pay is correct. Presently, I don't believe there is going to be any changes to the frequency of pay until 2025. So no need to worry about that, but it is something they're looking at doing in the future. So keep that in mind as well. And I'll hand over to Dan for some Respect at Work changes.
Oh, just to round out that superannuation, the change, I believe, is coming in 2026. And the change in terms of the frequency of pay just pertains to the minimum, the maximum time frame in which you have to pay superannuation. At the moment, you can make superannuation guarantee contributions once per quarter, but I believe that come 2026 it would need to be paid. The contributions need to be paid aligning with each payroll cycle that you have as well. Not something to worry about right now. That frequency of pay will come in a few years' time. So moving into Respect at Work, this is one of the big changes that we saw that's come through in recent times. And the reason why it's so relevant is to combat that sexual harassment, sex discrimination that occurs in the workplace from that proactive lens, rather than simply waiting for it to occur in the workplace and then dealing with it and responding to it in that reactive approach that we've always dealt with in the past. So that proactive approach to dealing with sexual harassment, sex discrimination in the workplace is what's known as that positive duty. And that positive duty imposes that legal obligation on employers to take that proactive and meaningful action to prevent sexual harassment, sex discrimination, victimization from occurring in the workplace, or in instances where there's that connection to work as well. So in terms of this, what we need to remember is that there's always been a duty of care that employers have had to ensure that there are safe working environments, ensuring that people are not being exposed to sexual harassment in the workplace. However, this positive duty, as I said before, just flips the switch around. Rather than dealing with it reactively, dealing with it in a proactive manner, and to eliminate that hostile environment as well. What we need to remember is that when it comes to matters like this, there are so many cases that go unreported. So whilst you may be aware of cases of sexual harassment that may occur in the workplace, really generally you only find out about this when someone comes to you and brings that to the forefront. There are instances where people might be afraid to raise these issues in the workplace, thinking that it may go against the grain, it may look as though they're not being a team player. They may be worried that they may see some sort of repercussion, or it may impact their career progression as well. There are other things such as embarrassment, fear of wanting to bring that up in the workplace or discuss it with their manager. There are a raft of reasons why. There are so many instances of sexual harassment, sex discrimination that occurs in the workplace that simply goes unreported. So Some examples in terms of what you can do to ensure that positive duty is having clear policies and procedures in place, providing appropriate support to employees, having clear methods for employees to voice complaints, and mandating training courses regarding sexual harassment and discrimination in the workplace as well. These are things that aren't just set and forget. Make sure that you're staying on top of these things so that you've got clear avenues for your employees to consider when they need to raise a grievance with you, and make sure that you've got that positive environment as well, where it allows them to feel comfortable coming forward. The other aspect to look at, that hostile environment, sorry, Jack, I think we've moved a slide too early, yeah. So that hostile environment to think about is a business's requirements to eliminate the behaviours in the workplace which has the potential to result in that hostile environment. And remember that the conduct doesn't have to be directed at a singular person, and instead it's just that conduct that results in that potentially offensive, intimidating or humiliating environment for others. And these can be things as that don't look bad on face value. It could be things like frequent jokes of a sexual nature, instances where people are laughing at something that may not essentially impact anyone in the immediate, but of course creates that environment, potentially a toxic environment as well, where it changes what the status quo is, and that expectation of what, you know, what's acceptable and unacceptable in the workplace. So remember, stay on top of these things, and try and call out behaviours as you see them, address them as employers, as people leaders, address them as quickly as possible, ensure that you're making it very clear that it's unacceptable as well, so you don't change what's acceptable in the workplace, and stay on top of this. So in terms of a quick recap, in terms of what is bullying, sexual harassment, discrimination, remember that bullying is that pattern of repeated behaviour. It's unreasonable behaviour directed at a person or a group of people, and most importantly, it creates that risk to health and safety as well. Don't let bullying continue in your workplace, because it does create that unsafe workplace environment. There are it impacts all sorts of things, such as productivity in the workplace. It creates risk to work cover claims, people feeling unhappy and becoming disengaged in the workplace as well, and generally creates that unsafe or hostile environment. What of course isn't bullying are those one-off instances, so it's not that repeated or pattern of behaviour. It doesn't mean that it's not it doesn't mean that it's appropriate behaviour in the workplace. It just simply doesn't constitute bullying or doesn't meet that threshold of bullying. Again, get on top of that behaviour as well, those antisocial, one-off, inappropriate behaviours that are not in line with policy or expected behaviours in the workplace. Ensure that you do address that as early as possible. Sexual harassment is unwelcome conduct of a sexual nature that a reasonable person would anticipate could make the person feel offended, humiliated, or intimidated. And examples of unwelcome conduct include things like sexual advances, requests for sexual favours, and other conduct of a sexual nature as well. These include things that are not so obvious as that. So it could be jokes of a sexual nature, putting posters up in the workplace, sexually suggestive comments, emails, posters that are up, things like this all constitute sexual harassment. Again, when we're moving into when we're looking at gender equity in the workplace, we really want to remove these sort of things from the sexual harassment from the workplace, because this obviously decreases participation of women in the workplace when they are having to come into work. And we know that sexual harassment is something that is experienced more so by women than it is by men in the workplace. So when we're looking at equal participation in the workplace, we need to ensure that we're creating these safe environments as well. So, what isn't sexual harassment, as we know, are things such as consensual relationships, mutual attractions, friendships in the workplace, but always be really mindful of this. those mutual relationships and attraction that occurs in the workplace from time to time, that it can create issues in the workplace, such as imbalance of power, health and safety issues. It can even create conflict of interest or reputational issues in the workplace as well. And then obviously, if we do see a fallout or a breakdown in the relationship, it can create issues in the workplace as well. If you are a small business employer, these relationships become even harder to tackle, where you don't really have that ability to separate the employees across different departments, different work sites and the like. And you might see that some of those issues, such as favoritism, perceived favoritism, and us versus them culture that starts to form in the workplace, that will become a lot more evident as well. So ensure that if this is something that comes up in your workplace a little bit, contemplate whether you wanted to introduce something like a workplace fraternization policy, disclosing relationships in the workplace and how you may deal with these as well. Reach out to us if this is something that you would like to explore. And the last is discrimination. Michael did touch on this earlier around the protected attributes. Remember that when it comes to discrimination, there are the two attributes, the two components that need to come into play. The first is the individual or group of people must have a protected attribute that exists. So these are things such as race, colour, sex, sexual orientation, and those new ones that Michael spoke with you about earlier, which is the gender identity, intersex status, and breastfeeding as well. So where there is a protected attribute, you must be careful that you're not taking adverse action against a person or a group of people based on that protected attribute. In doing so, it does create that general protections risk exposure, which again, Michael said, uncapped remedies, and it's that reverse onus of proof as well. It doesn't mean that these people are completely protected and you can't do anything against them at all. Don't be fearful of running things like performance improvement plans, conduct management. If you are looking at a organizational restructure and there are people with particular attributes that are going to be impacted as a result, it doesn't mean that you can't move on that. It's just that you need to make sure that you've got very robust processes in place and ensure that you've got clear impetus as well. So it allows you to defend a case if a general protections claim is to be made against you. So, for example, if someone would say you are commencing a performance improvement plan against me because of my age, you've got clear documentation in place to show that there's actually a history of poor performance that you can see from this individual. There are actions that have been taken to date to attempt to address that that poor performance, and you're simply moving to that performance improvement plan, not for any other reason that other than the fact that they have not performed well in the recent months. So that is a quick recap on bullying, sexual harassment and discrimination. Moving on in terms of what you can do. So remember to champion a safe working environment. I said this before, just around ensuring that you're as business owners, as managers in the workplace, ensuring that you're talking the talk, sorry, not just talking the talk, but walking the walk as well. You're not engaging in bullying, discriminatory or inappropriate sexual behaviours with other employees, and you should be acting as quickly as possible when these instances occur in the workplace. If you hear people making inappropriate comments, if you're seeing inappropriate comments being made on group chats, make sure you call it out straight away. And that's how you make that position of this being unacceptable conduct in the workplace. make sure that you're training your employees and having that focus on getting people in the workplace up to speed on what what your expectations are of them in the workplace, what their requirements are. And again, this shouldn't be something that is a set and forget. You do it once and that's it. You should be frequently setting and resetting that expectation in the workplace so people understand what is acceptable, what's above the line, what's below the line behavior. Taking that appropriate remedial action as well. When there is a complaint, treating that complaint carefully, confidentially, ensuring that you are doing something about it. Remember that if a complaint ever does land on your plate, people would have thought about that, probably debated over whether they would even raise that with you. It takes a lot of bravery to actually raise a complaint that pertains to sexual harassment or sex discrimination in the workplace, and even bullying, victimization, and the like. So make sure that you are taking appropriate action. That can include triaging the situation, doing a cultural review, investigating the circumstances, reviewing CCTV footage, or seeing what's actually occurred to then identify what action you need to take, and reach out to us as well if you wanted to seek guidance on how you might navigate complaints. And remember to be supportive. If you have EAP available, make sure that you are offering that to your employees, and make sure that you are making sure that they're okay. Again, it takes a lot of guts for them to raise that with you, and make sure that you're protecting the person that has raised the complaint, as well as any witnesses that may be there as well. Ensure that they're not being victimised through this process, and see whether there's anything else that you can do for them. That's it from me. I'll hand back over to Jack to discuss the modern award changes.
Thank you, Dan. So there's been changes to many awards around shutdown rules, and then there's also been some changes around family and domestic violence leave. So what we'll do is we'll talk about how we can manage a shutdown, and then also we're going to do a little bit on how employees can access family and domestic violence leave. It's not something that we would typically see in the past. And then also how you record it. Given the sensitivity of the leave, it's extremely important that you record it very differently to, say, annual or sick leave. So let's jump right into those shutdown changes I was speaking about. So what's actually changed is employers now need to provide 28 days notice of a shutdown. And in that notice, you will give a direction to take annual leave. An employee and an employer from there can agree to take unpaid leave or annual leave in advance should they not have enough balance, or maybe they have leave down the track. Say, if you're doing it over the Christmas period, they might have leave in February. That means if they took annual leave over the shutdown, they wouldn't be able to take it later. Unfortunately, with this one, it's not a great change for employees. It's quite biased. If employees don't respond to your notice, they don't make an agreement to take unpaid leave, they don't make an agreement to take annual leave in advance, they do actually have to be paid their ordinary hours worked over that period. And it won't come out of their leave balance. So the really important thing here is you give plenty of notice. You make it very clear throughout the year to employees, look, we shut down for 2-3 weeks over the Christmas period or over whatever other specified period you might have. And it's really important you have enough leave balance by them. We're going to direct you to take annual leave. And obviously 28 days is the minimum notice that you have to give. So I'd always strongly recommend giving a little bit more notice to make sure people know it's coming up, and incentivizing they take it. And if they don't have enough annual leave, maybe they're new to the business, get on the front foot. It's an agreement between you and the employee. So that means you can initiate the conversation as well. And say, hey, look, you don't have any annual leave. What about unpaid leave? Maybe you can take some annual leave in advance. But unfortunately, if they don't respond to make an agreement, it is ordinary wages. So I hate to be the bearer of bad news, but the best thing you can do here is get on the front foot. And try and stop it before it happens, really. So moving on to family and domestic violence leave. So I'll talk about what the changes are and how employees can access it. And then I'm going to get into a little bit around the why these have popped up and sort of the connection between family and domestic violence leave and the workplace. So what's changed is there's now 10 days of paid leave for all employees, and this includes your casual employees. Leave does not accrue from year to year, so it doesn't stack up like annual or sick leave. Rather, it resets back to 10 at the anniversary of your employment. So if I start tomorrow, I get 10 days, and then next year, 8th of December 2024, I would get 10 days again. So it would reset back to that. Something I mentioned earlier was that family and domestic violence leave has to be recorded confidentially. So if an employee requests family and domestic violence leave, make sure their payslip doesn't say it. A lot of the times you'll notice that partners or spouses might have access to someone's payslips or emails or something of that nature where you have their payslips available. And if they see that they've accessed family and domestic violence leave for a day rather than been at work, then it could result in something far worse, and it could make the problem bigger than it already is. So when does someone access this type of leave? It's when um, there's a threatening or abusive behavior by certain individuals known to the employee, or someone seeks to coerce and control the employee or cause fear and harm. Um, so they could use it for things like making arrangements for their safety or safety of a close relative, including relocation, attending court hearings, accessing police services, sorry, attending counseling or attending appointments with medical, financial, or legal professionals. The reason why this has come about and the reason why they've introduced this leave, extended this leave bucket and made it paid, is because family and domestic violence is now becoming a workplace issue. Not to bring up COVID and go back to that time again, but during COVID, you saw sort of a blurring of the lines between what a workplace is and what home is, and that boundary sort of broke down. And for a lot of people, before COVID, before the lockdowns, work's a safe place to get away from a really bad situation for potentially 8, 9, 10 hours a day. Whereas now it's they might be working from home, they might have flexible working arrangements, and it's a lot easier to request now, as Michael was saying earlier. So they could be exposed to that risk for a lot longer. And during the pandemic, we did see an increase in family and domestic violence leave cases. So in order to combat that, they've introduced this leave bucket, they've made it pay, they've made it 10 days, and they've opened it up to casual employees as well. And at the moment, where you'll probably see a lot more conversation around this leave type, as it's the 16 days of activism by the United Nations at the moment against gender-based violences. So we're right in the thick of it. You might see a lot more of this in the media spoken about, either amongst your employees on social media, wherever it might be. But yeah, the big takeaway here is be really sensitive when someone comes to you about this leave type. There's nothing wrong with coming to us if you have any questions about what kind of evidence do they need. But again, this is really similar to when someone's making a complaint about sexual harassment or bullying or discrimination. It's probably really difficult for them to raise that to their employer. It'd be a really hard thing to go to your employer and explain to them what's going on at home and why they need to access a legal or professional service. But if you do have doubts, or if you're a little bit unsure on how to record it, which is as normal hours worked, as I said before, or if you're unsure about what kind of evidence they need to provide, give us a call first. You don't want to get caught up and have a disgruntled employee when they've bought something really sensitive to you. So we're always here to assist you with that language as well. Now, moving on from that, I want to talk a little bit about what's to come. So as Dan said at the start of the presentation, there's been an unprecedented amount of change, and it looks like that's going to continue into the new year, and that's going to be with the Closing Loopholes Bill. So at the moment, it's just a bill, and essentially what that means is it's not an amendment like the other things we spoke about. It's just a proposal. It's some ideas of changes. So a lot of these that you can see, some of the dot points around new and casual employment definition, they could be changed, and they could even be altered a little bit because it has to go through the scrutiny of Parliament. And as it moves through Parliament, there's going to be new ideas, new suggestions until it is finally an amendment. But I'm going to talk about some of the prominent changes, some of the ones that probably affect your business and are relevant to you guys. So a new casual employment definition. Essentially what that means is they're going to be redefining casual employment and what it is. Over the last few years, there's been a blurring of the lines around a true casual and a regular and systematic casual. So a true casual is someone who doesn't have any guarantee of work. They work irregular hours. They might work 5 shifts one week, none the next, and then one the week following. However, in a lot of businesses, and what you see, and maybe even in your own, is casuals work from week to week, and there is an expectation of ongoing employment, which creates regular and systematic casuals. And then from there, they now have access to things like unfair dismissals, which an irregular or a true casual wouldn't have. So the Labor government's looking to redefine casual employment, put a definition around it, put a bit more rigor around it, so employers and employees understand their entitlements and there's a lot less confusion because it's caused a fair bit of headache. And then regulating sham contracting is the next one. So this is a fairly topical one. Essentially, the established legal principles were that whatever a business and a business, or an employer and an independent contractor agree to in writing, that's how the relationship is, and that's what stands. Through a few cases and over time, they developed a sniff test where they would say, well, what's the relationship in practice? How does it actually work? Does the employer have control over this independent contractor? Do they make them wear a uniform? Do they direct which hours they work, when they work, how they work? Do they have the ability to work for other businesses? And there's a lot more other common indicators around if someone's an employee or an independent contractor. And what they're looking to reintroduce, what they're looking to do is make the sniff test and some of those common indicators a part of the law, and make those the legal principles rather than falling back on what was in the contract. So that's a really significant one. And look, at the moment, if you do have a lot of independent contractors, or maybe you have an independent contractor that just works for you and you're a little bit confused, give us a call. We can help apply that sniff test to that individual, and we can assess your risk and talk to you a little bit more about those changes that might be coming in the new year, and see whether you may be at risk. Criminalising underpayments nationally. So if you're in the core and you're in Victoria and Queensland, you're probably already over this. It means that there's already criminalisation of underpayments has been added in the Crimes Act in Victoria and Queensland, and they're looking to do that nationally. So pretty straightforward there. And then casual employment sham arrangements. Now, this one relates to casual conversion and offering casual conversion. So they're looking to put a lot more rigor around casual employment. And that just means when someone hits that 12-month mark and they need to be offered casual conversion, the business needs to do it in writing, and the employee needs to respond in writing. So there's just going to be a little bit more rigor there. And as we get updates on these changes and new ideas start to come, and the proposal starts to take shape a bit more, of course, we'll let you guys know first thing and give you updates, particularly if it's risky to your business. But as always, if you're a little bit unsure about what's to come, feel free to give us a call and we can talk about it in a little bit more detail. But other than that, I think that concludes us for the presentation today. So thank you very much.
Thank you very much, everyone, for attending today. We've covered a bit today. Just remember that these aren't things that you need to remember. So you don't need to walk away remembering all of this today, but hopefully it's there floating around in the back of your head, so that if you ever come across a situation like this, please reach out to us, give us a call, and see if we can help in any way to shed some further light on this, or provide you with guidance around how to tackle a specific situation. There was a question that came in through the chat, and we've got a response there as well. But please, again, at the end of this, if you have any questions that you're worried about putting in the chat and you want to just discuss it directly with us, feel free to give us a call, and we're happy to run through your situation with you. That's it from us today. If you do have any questions right now that you're happy to ask, you're more than happy to take yourself off mute and ask the question as well. But otherwise, we might conclude. All right.
I think we have one person typing in the chat.
Okay. Well, we really appreciate everyone being here today, and fingers crossed that it isn't a mad dash to the end of the year for you all as well. And thank you so much.
Nice. Thank you all. Have a good one.
See ya.
Bye.